All right, thank you, gentlemen. Good afternoon. Today is Tuesday, September 24th, 2024, and we are gathered here for our Municipal Financial Recovery Advisory Committee meeting, MFRAC for short. I'd like to acknowledge we are joined by Mayor Roots on behalf of the City of Chester, Mr. Andrew Sheaf, Executive Director Andrew Sheaf on behalf of the Governor's Office and DCED, Ms. Kelly Diaz on behalf of Delaware County Council, and as always, joined by Mr. Kapoor and Mr. Cody Dale on behalf of the receivership team. I'm sure Councilman Davis will join us as soon as he can, but we're going to go ahead and get started. A summary of the meeting minutes, so to speak, were circulated by Mr. Dale. Hopefully everyone had a chance to receive them. And we have a presentation for today from Mr. Kapoor. But before we get into that, we'll pause for any comment. Mr. Dale, was there any public comment received since our last meeting?
So again, we haven't received any public comments aside from the Save CWA campaign emails. Those have continued, as they have slowed down, but they still continue. But other than that, no comments for the committee. So we'd just like to again encourage the public to reach out to the committee at info@chesterreceivership.com.
Thank you, Mr. Dale. Before we get into the presentation, any comments of the committee? All right. Well, Mr. Kapoor, I'm going to yield my updates for today in lieu of today's presentation and how long it is. But I'll give the floor to you.
Thank you, Mr. Receiver, and good afternoon to the members of the MFRAC as well as the public. Let me go ahead and take care of administration and share my screen here first, and just make sure that everybody can see the screen.
Yes.
Yep, great. Thank you. Thank you, Ms. Diaz. As Receiver noted, we have a fairly, I would call it a fairly lengthy presentation today, but one that I think is incredibly important and one that we know the public is I think interested in learning about, and that's to talk about an important question, and to start the next two MFRACs talking about really who owns the CWA. This is part one. We are going to be talking about how CWA board control was taken from the city of Chester. I think many of you who may be following this and maybe following the whole monetization issue have probably may have thought, well, this is the way the CWA board has always been. It's always had 3 members from the city, 3 members from Delaware County, and 3 members from the city of Chester. That's actually not the case. And what we'd like to do is talk about today kind of how the board governance and appointments changed. We have gotten a lot of questions over the past couple of weeks about a statement in that filing that the city of Chester owns the CWA. And not to hide the lead over here, but today's presentation is going to show how CWA board control was taken from the city of Chester without any compensation to the city. Now, for the purposes of the litigation, which we'll be talking about at the next MFRAC meeting, the city continues to maintain that the legislation that changed CWA's board that we'll discuss today had no impact on the city's authority to dissolve CWA or sell its assets, as the Commonwealth Court, we believe, correctly held in 2021. And I want to kind of put this discussion today in really in sort of larger context of what we've been seeing since we've been on the ground here, a little over 4 years. And the story here is one that from our perspective, really continues to show up in that the taking of CWA board control from the city of Chester without compensation is really another instance of Chester residents being taken advantage of. And we've seen sort of a long litany of what that looks like over the last couple of years while we've been here, right? It's having one of the largest trash incinerators in the U.S. Located in the city of Chester. It was the reduction of Delaware County Solid Waste Authority fees, host fees that were reduced for Delaware County trash years ago. The siting of the wastewater treatment plant, which serves much of Delaware County but is located here in Chester. The one-sided parking contract that was declared void by the Commonwealth Court. The incorrect pension calculation for certain police retirees that allowed pension spiking. And arbitration awards, fire interest arbitration award by arbitrator Edward O'Connell in 2011, and a 2012 police interest arbitration award by arbitrator Jay Goldstein, which provided compensation far in excess of what Chester could afford, and also increased pension benefits. So let me kind of go through the facts over here. We're not going to hide the lead, and we're also, going to provide what the facts are without pulling any punches. The CWA was formed by the city of Chester in 1939. And for the following decades, CWA provided water services to communities across Chester and Delaware counties. And during that period, the city of Chester appointed all CWA board members. All 5 CWA board members were appointed by the city of Chester. In 2012, the Pennsylvania General Assembly passed a law that fundamentally reshaped CWA's board appointment process and had a lasting impact on the city of Chester and its residents that continues to this day. So usually when a law like this is debated and discussed, it would be open to hearings. It would be open to public debate. You would have had elected officials talking about it. The media would have written stories about it. But none of that happened here. There were no hearings. There was no comment from elected officials. There were no stories ahead of time, and residents didn't even know that this was happening. And although the legislation itself didn't mention CWA or Chester by name, it was written in such a way that it would only apply to Chester and CWA. And it was quietly inserted as an amendment into an unrelated and uncontroversial bill late in the 2012 legislative session, budget session, when really nobody was paying attention. And so the end result was that the CWA board control was taken from the city of Chester and its residents, and they got nothing in return. And this presentation is going to show how that happened. So to kind of crystallize everything, into kind of one, I would almost call this the conclusion slide. And again, we're going to go through all of this this afternoon. But a summary of what the facts show is, despite CWA serving many Chester County and Delaware County municipalities for decades, while the Chester City Council was solely responsible for appointing CWA's board, in the waning days of the 2012 state budget negotiations, the Pennsylvania General Assembly changed CWA's governance structure at the 11th hour with legislation that was surgically designed to apply only to Chester, resulting in a majority of CWA board appointments remaining under the control of a political party that Chester residents had just ousted. And here's the key: without any compensation to Chester residents. So in terms of what we're going to go through today, in terms of the outline, we're going to talk a little bit about the Municipal Authorities Act. We've talked a little bit about that before. I think by the time receivership is over, those of you who are going to be watching this will probably become experts in this area. We're going to be talking about the MAA. How did Section 5610A1 become law? That was the section that took board control away from Chester. How did that become law? Why did it happen? And then we'll talk a little bit about the next presentation. So let's look at the MAA provisions on the authority board member appointments. So under the Municipalities Authorities Act, that provides for the board structure of authorities and appointments to them. That sets how many board members you have, as well as who gets to appoint those board members. And so prior to 2012, the sole determining factor, so the only determining factor under the MAA for the board structure and the appointments, was whether the authority was incorporated by one municipality, which was a single municipal authority, or whether it was incorporated by more than one municipality, which is a joint municipal authority. But after the 2012 legislation, there was a new provision, a new specific provision that was added to the MAA that directed changes to the board structure and appointments of a water authority, again, with hyper-specific characteristics, which in reality only applied to CWA. So let's look at those different categories of how the MAA sets the board composition. So 5610A1 provides in relevant part if the authority is incorporated by one municipality. A single municipality, the board will consist of no less than 5 members, and the governing body shall appoint the members of the board. So it's no less than 5, and it's all appointed by the municipality that incorporated the authority. And so we'll note that the Chester Water Authority was actually incorporated by only one municipality. That was the city of Chester. So prior to the 2012 legislative changes, that above language applied to Chester and the CWA. And I also call your attention to the only factor here that the MAA uses is incorporation. It's not service delivery area. It is which entity incorporated the authority. So an authority that provides services to other jurisdictions, but was only incorporated by one municipality, would have all of its board members appointed by the incorporating municipality, except for, as we'll see in a moment, CWA. Then you've got another provision, 55610A2, that deals with joint authorities. And this is if an authority is incorporated by two or more municipalities. Again, the board is set, shall consist of a number of members, at least equal to the number of municipalities incorporating the authority, but in no event less than 5. And again, what you have is the entities that incorporated the authority are the ones who appoint the board members, not where service delivery is provided. There is some language in there that talks about municipalities that join the authority, but that's more than just service delivery. That's section 5604 of the MAA. To join an authority, there's a specific provision in there that did not occur with the CWA. So let's talk about the provision that applies to CWA and what happened in 2012. So in 2012, the following provision, and this is provision 5610A1, was added to the Municipal Authorities Act. And this is the language. If a water or sewer authority incorporated by one municipality provides water or sewer services to residents in at least 2 counties and has water or sewer projects in more than 2 counties, where the combined population of the served municipalities, excluding the incorporating municipality, is at least 5 times the population of the incorporating municipality, all of the following apply. And so basically you can see down here, what happens is the board is replaced within 90 days after the effective date. 3 members are appointed by the governing body from each county in which the services to residents are provided. So what happens over here is you see a fundamental change in the way the board appointments are made. Prior to 2012, for every authority, it was all based on incorporation. But here, again, for this specific entity, and we're going to go through it in some detail, it was changed to service provision. And again, only for an entity that met all of these qualifications. So to summarize, and again, this applies to all water and sewer authorities in Pennsylvania. The Municipal Authorities Act does. You've got one set of rules for an authority that is incorporated by one municipality. You've got one set of rules for an authority incorporated by 2 or more municipalities. And then you've got one set of rules for a water or sewer authority incorporated by one municipality that provides water or sewer services to residents in at least 2 counties and has water or sewer projects in more than 2 counties where the combined population of the served municipalities, excluding the incorporating municipality, is at least 5 times the population of the incorporating municipality. And obviously, to the best of our knowledge, the only authority in Pennsylvania that meets this criteria, right, is the Chester Water Authority. And so now what I'd like to do is kind of go through the various components of how hyper-specific this section is. And I'll say to you, to the public, I'm a lawyer by trade. I am used to, let me just say, kind of reading legislation, reading case law and otherwise. But I've never seen something quite like this before, right? Where you've got something like the Municipal Authorities Act that, again, applies to all authorities across the Commonwealth and has one set for single incorporated, one set for joint, and then you've got this. So, what I've done our best on here, and again, we're going to go through this, so I'm not going to reread it, but you'll see in the different colors over here, these are the various factors that have to be met in order for this provision to apply. And each one of these different colors is kind of is its own characteristic, right? And again, all of them have to be met. And while I said that I was an attorney, right, I can read stuff like this and kind of see what's happening, right? But if a member of the public looks at this without any other context, this would be nearly impossible to realize that it applied to the CWA. And from our perspective, that seems intentional, as we will see later, given the way that the language became law. And it's clearly written to exclude every other water or sewer authority in the Commonwealth except the CWA without explicitly saying so. So let's now go through each one of these categories, right? So the first says it's got to be incorporated by one municipality, right? And again, in Chester's case, the CWA was the only municipality to incorporate the CWA. If more than one municipality incorporated the CWA, 5610A1 would not apply. Okay, so you got to be a single municipal authority, which Chester Water Authority was. Next, you've got to provide water or sewer services to residents in at least 2 counties, right? And CWA in 2012 provided water services to residents in Delaware and Chester counties. So if the authority provides services to residents in multiple municipalities, but they all live in the same county, this provision would not apply, right? You can see how this language is being crafted to start to exclude, other authorities, right? So you've got to provide water or sewer services to residents in at least 2 counties. And here's where it really gets kind of, surgically designed. The next element is it has to have water or sewer projects. And the legislation refers to projects essentially as assets in more than 2 counties, And this language means that the assets need to be in at least 3 counties, right? More than 2 counties means at least 3. It's got to be 3 or more. And part of the Octorara Reservoir is in Lancaster County. So if the authority only had assets in 2 counties, this provision wouldn't apply. And so it's kind of odd, right? In the previous requirement, you say that the authority's got to provide water services to residents in at least 2 counties. It's kind of odd that it says, okay, you got to provide it in 2 counties, at least 2 counties, but this provision would not apply to an authority that provided services to residents in 2 counties, but only had assets in those 2 counties. Right? So you would think in most entities out there, if you did provide it to services in 2 counties, all your assets would just be in those 2 counties, right? But this language is specifically designed to say it's got to be at least 3 counties, right? So that part of the Octorara Reservoir that is in Lancaster County, that allows CWA to fall over this provision. And then the final aspect of it, it says, where the combined population of the served municipalities, excluding the incorporating municipality, is at least 5 times the population of the incorporating municipality. So this is an extremely specific population requirement. Why 5 times? Why at least 5 times? Why not 6? Why not 7? Right? There's nothing on its face in this legislation that would suggest why it would be 5. And again, it just so happens, right, that the Chester Water Authority, the combined population of the served municipalities, excluding the city of Chester, is at least 5 times the population of the city of Chester. So, you may be asking at this point, well, why couldn't the MMA just explicitly say that provision only applies to the Chester Water Authority instead of going through all that trouble that it does? And the issue is, it's a really big issue, right? Section 5610A1 could not explicitly reference just the CWA, even though practically that's what it does, because the legislation implementing that language would be considered, quote, special legislation, which is unconstitutional under the Pennsylvania Constitution. So basically, if you had said this applies to the Chester Water Authority, it could have been challenged on the grounds that it was special legislation. And it still could potentially be challenged. And we're not waiving our right to challenge the constitutionality of Section 5610A1. The city is not doing that. I want to be very clear about that. But again, for folks at home who are kind of looking at this and saying, well, why didn't you just say it, right? If that was your intent, why didn't you just say it? And that's a fundamental reason, including, probably not wanting to be so overt about what the language did. So let's talk a little bit about how Section 5610A1 became law. And this is also an incredibly interesting story. In 2012, Senate Bill 375 amended the MAA to add that. So when legislation is changed, or excuse me, when laws are changed, it's got to be done through legislation. And it's done through either a House bill or a Senate bill in Pennsylvania. And in 2012, this was Senate Bill 375. The prime sponsor of the bill was then State Senator Dominic Pileggi, a Republican from Chester, who previously served as the mayor of Chester and was also the state Senate Majority Leader at the time. And so also at this time, back in 2012, Republicans controlled the state House, the state Senate, and also the governor's office. So they controlled all, both the state House, the state Senate, and the governor's office. And so what you will be able to see from the legislative history of Senate Bill 375 is for over 16 months, the pending bill 375 simply prohibited authorities from spending money on things not related to their mission. Then, with 18 days left until the state budget deadline, Senate Bill 375 was suddenly amended in the Senate Rules Committee to include the section we talked about. It was then passed the very next day by the full Senate and then passed by the full House 6 days later. So it took over 16 months from the bill's introduction to include that section in the bill, and only 7 days after that section was included to pass the bill in both the House and the Senate once the language was in the bill. And we're going to go through the legislative history, right? I'm going to kind of walk you through where it goes. It is online, so all of this can be found if folks want to double check me here. It can all be found on the legislature's website at this link, and then you search for Senate Bill 375 during the 2011-2012 regular season. I do know, there are probably folks here who are watching this who are familiar with the legislative process. Some folks who may work in the legislature, some folks who are attorneys who know how the process works. You will quickly recognize what happened here. You will quickly recognize that what was clearly done here was slipping an amendment to a bill in at the end of a budget session in order to get it through without debate. So again, I don't want to pull any punches. I don't want to bury the lead. But to any of my friends in the legislature who are watching this, I think you know what happened here. So let's look at this, right? This is the bill information. This is history. Again, this is on the website, the legislative website, the link. And what I have over here is, again, different parts of that history that again we'll go through. So February 4th, 2011. This is when the bill was initially introduced. And this was referred to the local government committee in the Senate. It was introduced in the Senate. The prime sponsor was Senator Pileggi. And again, the text had to do with the prohibition of the use of money for any purpose other than a service or project directly related to the mission or purpose of an authority. What had been happening over the years was authorities were sometimes supplementing the general funds of the municipalities. And there was a concern kind of across the state about using ratepayer dollars in order to do that. And so this bill was introduced in order to address that issue. So on April 12th of 2011, it gets reported out of committee. There's still nothing about changing the governance structure or the appointments of water or sewer authority boards. April 27th, 2011, it's referred to the Senate Appropriations Committee. December 12th, 2011, the Senate Appropriations Committee votes unanimously to send it to the full Senate. And then December 14th, 2011, the Senate votes unanimously 50-0 to approve the bill. So it's over 10 months since the bill introduction, and there's still nothing about changing the governance structure or appointments of water or sewer authority boards. It's still all about how authorities would use money. And then we go to the next section, right? So from the Senate, it goes to the House, if everybody remembers their civics, right? So it goes to the House. December 15th, 2011, the bill is referred to the House Local Government Committee. March 26, 2012, the Local Government Committee in the House approves the bill unanimously, and then it sends it to the House for full consideration. So at this point, right, the bill has been introduced and it's been pending for over a year. It was introduced in February 4th of 2011, and it's now March 26th of 2012. And there's still nothing in there about changing the governance structure or appointments of water or sewer authority boards. Now we get to April 3rd, 2012. It's amended in the House. There's a couple amendments in there allowing contributions to nonprofits, joint equipment purchases, and equipment sharing. But nothing in there about changing governance. April 4th, the House approves the bill as amended unanimously, 194-0. So because it got approved by the House as amended, it's got to go back to the Senate. The Senate's got to vote on it. 14 months after the bill's introduction, we're 14 months in, and there's still nothing about changing the governance structure or appointments of water or sewer authority boards. So now we're back in the Senate, and it's April 30th of 2012. And here's where things get weird, right? and again, I would ask my friends who know the way legislation is done in Pennsylvania to pay particular attention now. The bill is referred to the Rules and Executive Nominations Committee, which is an extremely powerful committee in the Pennsylvania State Senate. I'll note for everybody here who doesn't know this, June 30th is the end of the Commonwealth's fiscal year, and it's the unofficial deadline for budget passage. So what's happening over here is we're getting very close to the end of the budget fiscal year, right? And that happens on June 30th. So, we're at the end of April. It's referred to the Rules and Executive Nominations Committee. And then it sits there for a little while. Then all of a sudden it shows up on June 12th of 2012. The bill, it's amended in the Rules and Executive Nominations Committee to include, for the first time, the language in Section 5610A1, which takes CWA board control away from Chester without compensation. So this is the first time that we see that language appear in over 16 months at that point. So June 13th, the very next day, right? It comes out of committee, has this language in there, this kind of confusing language in there. And then the very next day on June 13th, 2012, the full Senate passes the bill unanimously with that amendment in it, with no debate. There's no debate. Comes from the committee, voted there unanimously, goes to the Senate floor, their vote is voted unanimously. And again, note the date, it's June 13th. So this is 17 days away from the end of the fiscal year. Same day it gets passed in the Senate, it gets referred to the House Rules Committee. So it goes straight from the Senate to the House. We're not missing a beat over here. On June 19th of 2012, only a couple days later, the House Rules Committee passes the bill and the full House passes the bill unanimously, 196-0. And so again, I'll call attention to my friends who know legislative process. The House fiscal note, every bill has to have a fiscal note, which was the first time we see Section 5610A1 appearing in a fiscal note, was dated June 19th of 2012, the same day as the full House vote, right? So typically when you're looking at legislation, you're looking at fiscal notes, you're looking at the way amendments, you're looking at votes and all that. This fiscal note shows up and is dated the very same day it comes out of committee in the House and is voted on the House. So it took over 16 months from the bill's introduction to include Section 5610A1 in the bill, and only 7 days to pass the bill in both the House and the Senate once the language was in the bill. And so, was there any debate? Well, the House Legislative Journal on June 19th has a little bit of language, and this is what was said about that bill. And this is, quote, Senate Bill 375 came over in December of 2011 with a 50-0 vote, and then the House made some minor amendments in April of 12 and sent it back to the Senate on a 194-0 vote. The Senate on June 13th, by a 47-0 vote, actually made a few more amendments, and the Senate amendments provide for membership on authority boards under certain circumstances where a municipal authority is incorporated by a single municipality but serves part of at least 2 counties, and the service area outside of the incorporating municipality is 5 times larger than the incorporating municipality. The county commissioners in those counties would get to appoint members to the authority board. These additional members would represent authority customers on rates, service problems, and other issues. As I indicated, this passed the Senate 47-0 on June 13th of 2012. It has moved out of the Rules Committee, and we would like to put it on the governor's desk. Please vote yes. Thank you. This is Representative Mike Turzai. That was it. And then after that, it was voted on. Nothing about how this impacts the Chester Water Authority, nothing about the reason for why this was done. Didn't even talk about the assets, the projects, about needing to be in more than 3 counties, right? And so if you look at this, if you're a legislator, right, and this is being rushed through at the end of the budget season, this is you assume it doesn't apply to yourself, and you move on, right? And then again, it gets voted on, and then the governor signed it a couple days later. So did the city of Chester receive any compensation for Senate Bill 375, taking away its board control? The answer is no. It was taken away, simply taken away. And so did the city of Chester elected officials agree to Senate Bill 375? That's also no. And we have an August 31, 2012 Delco Times article, which I linked to at the bottom here, quoting then recently elected Mayor John Linder, a Democrat. That'll be important in a moment. was described as being, quote, unhappy with the changes, end quote, and quoted as saying, my only observation is that it was good enough all the way up until now. It certainly takes authority away from the city. I don't appreciate it. And then in that same article, then State Representative Thaddeus Kirkland, future mayor, who did vote for the bill, stated, quote, that was a bait and switch move. They did it at the last minute. Usually when you stockpile those bills on top of one another, it's too late. You don't have time to read all the legislation. And so again, you can see then Representative Kirkland over here saying, look, this was basically rammed through, and done so in a way that was clearly not transparent. And again, you have heard perhaps those of us on the receiver side perhaps be sometimes critical of Mr. Kirkland, but I think this is exactly what happened over here, based on both the language of the amendment as well as how this was passed. And so let's kind of continue on, right? The article also summarizes the position of Senator Pileggi's office on Senate Bill 375, saying, quote, the law, and this is a quote from the Delco Times article, the law ensures all ratepayers have representation on the board of any water or sewer authority, which was incorporated by a single municipality, but serves residents in multiple municipalities and multiple counties, according to Pileggi's staff. Now, that's not true, right? That's not fully accurate. And again, you got to be careful. Sometimes quotes may not be attributed properly in the newspaper. I know reporters do their best, but this just wasn't incorporated by a single municipality, but serves residents in multiple municipalities and multiple counties. We saw the language in there. It has to do with the assets that it has in more than 2 counties. It has to do with the population. So it wasn't just something that applied to all authorities, right? It was surgically designed to apply to the Chester Water Authority. And then Senator Pileggi's spokesperson, Eric Aronson, said, legislators followed the normal legislative process with this bill, and there was nothing improper about it. I did add the followed the normal legislative process in italics, because again, you question whether this is the normal legislative process. Typically, there's debate. Typically, amendments are voted on the floor. Certainly for a bill that was as important as this one. There were also more recent comments regarding Senate Bill 375 from Representative John Lawrence, Republican from West Grove, Chester County, who did vote for Senate Bill 375 as well in 2012. Most recently quoted in the Delco Times saying, quote, the CWA board was established by a unanimously passed law that's been on the books for more than a decade. The receiver is asking a judge to completely disregard and nullify a duly passed law of the Commonwealth of Pennsylvania. It is outrageous. That's in the September 15th Delco Times article, Chester Police Want Possibility of Privatized Water Assets. So let's take a moment and kind of ask the question, right? So why did this happen, right? Like, why was the language drafted the way it was? Why was it passed the way it was passed in the legislative process? And it raises a lot of questions, right? It raises a lot of questions for people who may be watching this. And again, regardless kind of where you fall on the monetization debate, right? I mean, you can still be opposed to monetization, right? And feel the way that this wasn't done the right way. But I'm asking kind of folks to be as objective as they possibly can, as we talk through this. And it does raise some really important questions, right? So the first is why, after decades of CWA providing service to multiple municipalities, was the MAA amended to specifically single out Chester and the CWA? So why do you do this in 2012 and not earlier, right? We've been providing these services to these communities for decades. Why didn't you do it in the 80s? Why didn't you do it in the 90s? Why didn't you do it in the early 2000s? Why did you wait until 2012 in June of 2012 to do this? And if the concern was board appointment by municipalities who were served other than the incorporating municipality, why was this legislation so narrowly tailored to Chester and the CWA? So some of you may be arguing, well, look, like, we think that if this provides, if an authority provides services to places in other jurisdictions, they should have a say. But That's not what this legislation did, right? It narrowly focused on Chester. So why didn't you have Senate Bill 375 apply to all single water and sewer authorities who serve other jurisdictions, right? And the questions of process, right? Why was the legislation added to the non-controversial bipartisan bill last minute? As you saw, that bill was pending for 16 months. So why wasn't it added earlier? And why weren't Chester residents informed? Why wasn't this discussed more publicly? And so was there something else going on that might explain why Chester's ability to appoint CWA board members was taken away in 2012? I would suggest that the answer is yes, and we'll get to that in a moment. So the first question might be, if you're looking at this again objectively, and we're doing our best to do so here, is to ask the question of, well, was the CWA's service area significantly expanded in 2012? Right. So were they kind of only servicing a small area, and then all of a sudden in 2012 they expanded, right, to hit a lot of communities in Chester County and Delaware County? And the answer is no. The CWA had provided water services to other Delaware County and Chester County municipalities for decades prior to 2012. And all through that period, the city of Chester appointed all 5 CWA board members. If you really want to go back in history, the Octorara Reservoir was impounded, so it was created in 1951, and the treatment plant was built in the 1950s. And if you go to the CWA website, which is what we did, there's a really interesting history of the CWA. It's online. You can download it. And the image above here is from page 74 of the History of Chester Water Authority, 1865 to 1985. And you can see in here a map that shows the service area of all the way out to Chester County and the city of Chester, right? So these services had been provided for decades. It wasn't as if the CWA all of a sudden expanded in 2012. So this is Delaware County. Again, to pull no punches. What was the political environment in Chester at the time? And those of you who have lived in Chester all your lives, those of you who have studied Chester, those of you who, like me, are sort of kind of new here, but learning a lot, know that it has been well documented in a variety of books, such as Politics and Prejudice by Richard Harris, Race and the Politics of Deception by Christopher Maylay, and Ruling Suburbia by John Morrison McLaurin III, that the city of Chester had served as the headquarters of a Republican political machine in Delaware County for decades. That is a fact. Both Politics and Prejudice, Race and the Politics of Deception, you can get off of Amazon. Ruling Suburbia is out of print, but you can get it off of Google Books. And again, I strongly suggest to anyone who is interested in the history of Chester to get it. And so what was happening was at this time, right, and that machine had a lot to do with the jobs that people got in Delaware County and got in the city of Chester. But what was happening by the late 2000s was that Democrats were beginning to win city council seats, which had been in majority controlled by Republicans. So in 2009, there were 2 Democrats, John Linder and Portia West, who defeated Republicans Fred Pickett and Marcia Taylor, which resulted in 2 of the 5 council seats being held by Democrats. Got 5 council seats over here, including the mayor. And so at that time, the Republicans still outvoted the Democrats 3-2 by 2009. But in November 8th of 2011, Democrat John Linder defeated Republican Wendell Butler in the election for mayor. And this was only the second time since 1905 that a Democrat had been elected mayor, and the first since 1995. And so what also happened at that election were Democrats Nafis Nichols and Elizabeth Williams defeated Republicans Shepard Gardner and Nolan Woodland in the election for city council. And the result of that was that Democrats now held all seats on Chester City Council. Then Mayor-elect Linder and Democrats Nichols and Williams all took office in January of 2012. And so at this time, this election resulted in a majority Democratic Chester City Council being able to appoint a majority of the CWA board members for the first time in decades and perhaps ever. Because remember, at this time, you only had those 2 provisions in the MAA, the single authority and the joint authority. You didn't have the other one that was passed in 2012. So at this time, all of a sudden, the control, right, the ability to appoint board members, right, was in the hands of the Democrats. And so what was going on, though, at the county level, right? Because remember what this provision did was it ended up with 3 appointments by Chester City, 3 appointments from Delaware County, and 3 appointments from Chester County, right? So the Delaware County plus the Chester County is 6, and then you have Chester City, right? So 6 is obviously it's more than 3. And so what was happening in 2012, if we looked at the in the county area, both the majority of Chester County commissioners and Delaware County Council were Republican controlled. The Democrats did not win majorities on these boards until 2020. So from 2012, in 2012 and prior to that, the majorities on both of those areas were Republican controlled. And so under 5610, now the Chester County commissioners and the Delaware County Council were able to appoint 3 CWA board members each for the first time. And what they did was, and you can see it from the article, was they appointed all Republican board members, including the former Chester City mayor, who had just been defeated in the November 2011 election. Chester County appointed 3 Republicans, and Delaware County appointed 3 Republicans. So therefore, if you look at that, the change to the MAA in 2012 resulted in the CWA board appointments remaining under the control of a political party that Chester residents had just ousted after decades of control. Right? So, I mean, what the clear message is over here is why this was done was political. It was a political power move. That's what the evidence shows here, right? And again, despite CWA serving many Chester County and Delaware County municipalities for decades, while Chester City Council was solely responsible for appointing CWA's board, in the waning days of the 2012 state budget negotiations, the Pennsylvania General Assembly changed CWA's governance structure at the 11th hour, with legislation surgically designed to apply only to Chester, resulting in a majority of CWA board appointments remaining under the control of a political party that Chester residents had just ousted. And again, really importantly, without any compensation to Chester residents. And so, I asked those of you who are watching this now and who will watch this in the future, again, to try and do your best to be objective, right? You can still be opposed to monetizing the system, and still think that there was something off here. But I really want folks to ask themselves this question: is kind of knowing what you know now about how this legislation was passed, right? Do you think it's fair to the residents of Chester that, unlike every other Pennsylvania municipality that incorporated an authority, their ability to appoint a majority of board members to an authority that their city incorporated was taken away from them without any compensation? Is that fair to the residents of Chester? So next time, on October 8th, we're going to continue this question of answering the question or discussing the question of who owns the CWA. That'll be at the next MFRAC meeting on October 8th of 2024 at 1 p.m. We're going to spend a lot of time there discussing the appeal of the Commonwealth Court's decision ruling that Chester owns the CWA, which is pending before the Pennsylvania Supreme Court. We thought it was important to go through this history, and it is important. You'll see that when we do the next presentation to kind of understand the language in here and why that's important for the litigation. Again, the city maintains that the legislation changing CWA's board had no impact on the city's authority to dissolve CWA or sell its assets, as the Commonwealth Court correctly held in 2021. So again, you can watch it here live or recorded on the receiver's Facebook page at facebook.com/Chester Receivership. So that concludes my presentation. I appreciate your attention, and happy to either answer any questions or listen to comment.
Well, Mr. Kapoor, we certainly thank you for another thorough presentation. My questions may be a little more targeted, so I'll wait a second as I've had a chance to digest this ahead of the committee members. Is there anyone on committee that would like to ask a question of Mr. Kapoor or myself? All right. I will get us started then. One of my main takeaways, Mr. Kapoor, is that governance does not imply ownership, that a change in governance does not imply a change in ownership. Um, are you aware, or is anyone on the committee aware of any governance issues with CWA prior to 2012?
I am certainly not, and there was nothing in any newspaper articles that we reviewed, nor in the legislative history that suggested that there was.
And so we see in the 2012 bill amendment, the wording of incorporated by a single municipality, whether it be prior to 2012, the action in 2012, or the Commonwealth Court decision of 2021, there's no change in that recognition that CWA was incorporated by a single municipality.
That's correct.
Would you be able to compare and contrast this to Delcora water system and what the municipalities have in reversionary interest?
Right. So that's an interesting kind of comparison, right? And if we talk about Delcora, many of you may remember that Delcora was created, I believe, in 1971, by aggregating a lot of the different sewer systems that were across Delaware County into one, including the city of Chester's. And what was included in that agreement when Delcora was created was something referred to as a reversionary interest. And effectively what that meant was that if at any point Delcora ceased to operate the system, then the municipalities would effectively get their assets back. It would revert back to those municipalities. You know, and there very much so, you had municipalities coming together to create a new authority. In the city of Chester's situation, you had a single city municipality that incorporated this authority and did so basically in the late 1930s. And it grew its service area while always remaining under the ownership of the city of Chester, and also for its board governance under the Municipal Authorities Act, because it was a single authority, having the ability to appoint all 5 of the CWA board members up until the legislation changed in 2012.
Thank you for that, Mr. Kapoor.
Yeah, I'm sorry, go ahead.
No, was there more to?
Well, again, it's different over here in you know, from the position of the Chester Water Authority, right? And which makes this kind of a little bit even kind of more galling, I think, from the perspective of the residents and from the city, is that there's no disagreement that the city of Chester incorporated this and solely incorporated this, right? You wouldn't be having this debate with any other water or sewer authority in the Commonwealth of Pennsylvania, because they would be the ones that were appointing the board. The only reason that you have this debate here in the CWA is because of that provision, is because of 5610A1. It wouldn't even be raised in every other water or sewer authority that's incorporated by a single municipality in the Commonwealth. Here, I think you're on mute.
Thank you, sir. To speak to what is outrageous, taking a city asset without any compensation certainly fits that description. Did you mention, I don't think I saw it there, anything about staggering terms? Are all board members now, their reappointment they're all at the same time?
I believe that's the case. I mean, one of the other things that was done by the legislation that I didn't include in here, but I probably should have, was when this was changed. So when in 2012, 90 days after the effective date, right? So when those different parties appointed their members, each one of those members had a term for 5 years. Now, under the Municipal Authorities Act, the way that was done before was they were staggered terms. What would happen is when you first incorporated it, you would have one individual who would be there for 5 years, then another for 4 years, then 3, then 2, then 1. And so what would happen is you would have every year the municipality would be cycling through and they would be appointing somebody new to the board. The impact of what was done in this legislation by saying everybody's going to have a 5-year term is you've taken all that away. You've literally taken the ability for the municipal, because that's what would have happened. What would have happened under the old, prior to 2012, would have been that the city of Chester would then have been able to appoint one member in, in 2012, right? And then they would have been able to appoint another member in 2013. And then by the time you were in 2014, you would have again, if we're looking at this from a strictly political end, you would have had a majority of the board members of CWA then appointed by Democrats within 3 years. But by then, even then, by adding that additional, by changing those terms to 5 years, what you've done is you've completely locked that in for a 5-year basis, right? And that's important, right? Because that also impacts the appointments on the county councils, right? That kicked everything out for 5 years, and it basically froze and protected that political arrangement for at least 5 years.
And to bring that to present day, Mayor Roots may know the answer offhand. I believe all 3 appointments by the city were made in 2023. So there will be no board appointments from city administration for the term of Mayor Roots, 4-year term as mayor. Is that correct?
I am not certain on the dates, but that does sound correct. And I think to take it a step further, aren't all the terms, don't they all expire in the same year for the city,
Yes.
the county, and Delaware County and Chester County? So all 9 get flipped at one time.
For that. So my last question, I think, is just about leadership at the time. Was there any objection? Did we find any objection from CWA leadership, the solicitor, the executive director, board members? Did anyone object to immediately changing their board structure given this this new legislation?
There were nothing in news articles about this. The only people that appeared to be upset by this were elected officials that were serving Chester.
Thank you, Mr. Kapoor, for answering my questions. But one last time before we conclude today's meeting, are there any questions or comments for anyone on the committee? Well, hearing none, I want to thank everyone again for meeting with us here today. I believe, Mr. Kapoor, you indicated that the next meeting will be October 8th at 1 p.m. We are open and available between now and then, but if nothing else, we look forward to seeing you then. Thank you. This meeting is adjourned.